Welcome to the Trial Lawyers Injury Podcast with David Zagoria.
Welcome to the Trial Lawyers Injury Podcast with David Zagoria of Zagoria, Neely Injury Attorneys. David is a former prosecutor who now represents injury victims across Georgia in serious cases involving dog attacks, car wrecks, premises liability, and wrongful death claims. Known for his courtroom experience and strategic approach to litigation, David helps clients understand how injury cases are investigated, proven, negotiated, and tried. I'm Shameika Rhymes, and today we're talking about how dog bite cases are proven in Georgia and what evidence matters most. Welcome back, David.
Hey, good to see you again, Shameika. Thank you.
Well, David, what has to be proven in a Georgia dog bite case before the conversation ever gets to the value of the injury?
So that's a great question. So there's really two different types of cases we have, and I'll break them down to help the listeners understand. The first kind of case you're going to have is a case against a landlord. Well, why would you bring a case against a landlord? A lot of times it's when there are multi-use apartments. It could be mobile homes. It could be townhomes, condominiums. Anytime there's multi-tenants and that there's a landlord or property management company that is in control of that. In those cases, if the actual dog owner, who perhaps is a renter, has no insurance and is judgment proof, meaning they don't own their home, how are we going to collect money? A lot of times the target then needs to be on the landlord or the property manager. And in order to win a case against the property manager or landlord, we're going to have to show two things. One, that the landlord was aware of the hazard on the property, and the hazard on the property is an aggressive dog. So we're going to have to prove that the landlord knew they had an aggressive dog on the property. And then the second prong of that evaluation is that the attack or incident has to have occurred in a common area. So if the attack occurs inside the tenant's apartment, that's a private area that the landlord has no control over. Landlord's not liable. But if it's the tennis courts, walkways, pool, workout rooms, those are common areas for the benefit of all tenants and a common area. So the landlord would be responsible for hazards in those areas. Really similarly, like if there was water spills or any sort of premises liability hazard, the dog bite case would fall under that umbrella. And the dog is actually the defect or the dangerous instrumentality on the property. Now, those cases are much more rare. What we typically have is a single family home and they have a dog and it gets out and it bites somebody. In that situation, when it is not a case against the landlord, what we're looking at is first, where did the bite occur? Meaning, where is the location? If it occurred inside the dog owner's home, we're talking about a very difficult technical case because we're going to have to prove one of two things. We're going to have to either prove there was a prior act of aggression towards people. So if the dog has attacked and killed cats or other dogs or rabbits and squirrels, that does not count. It has to be prior acts of aggression towards people. And the courts have said that could be anything from chasing people, attempting to bite people. And of course, the best evidence is that the dog's actually bitten someone. So if the attack occurs when the dog is confined, and I mentioned earlier, that could be inside a house, but it could also be if it's fenced in the backyard, or if the dog's walking on a leash, it's restrained. So if it's restrained, you're going to have to find that evidence of a prior aggression, which leads me to the other way we're going to prove a case when the bite occurs and it's a single family home dog owner. And that is if the dog is off leash and the owner is aware at the time of the incident that their dog is off leash, then we're going to have the necessary evidence to prove liability. Then along with that, any of those versions, you still have to prove careless management or allowed the dog to go at liberty. So obviously the leash one, allowing the dog to go at liberty, doesn't count, but careless management would. That's essentially how it works in a nutshell.
Okay. So I'm just curious, if you are in a townhome and your driveways are literally right on each other, how does that work then? the same kind of thing?
So it would have to be if the townhome is owned by a single individual and it's
Mhm.
not a landlord or property manager, then it's not going to fall under the umbrella of needing to prove common area. It's
Okay.
simply going to be a dog owner, their home, their dog was either out and off leash or it wasn't. So if it was out and off leash, and keep in mind, there has to be a leash law ordinance. There are many, many counties in Georgia that have no leash law. So in those counties, you always have to prove that the dog was vicious, meaning it's bitten, attempted to bite,
Mhm.
chased people. So that's a little wrinkle there. So your question is really good, but in the townhome situation, it would only be where they're renters and there's a property owner managing those properties.
Okay. All right. I'm grateful that I have 2 dog owners on either side of me, and those dogs, they just are so sweet.
Well, that's good, but if
Yes.
they were to bite you,
Mhm.
if you were a guest in their townhome, you have to find a prior aggressive act. If you were in your driveway and they were running loose and you live in a county where there's a leash law ordinance, you have to prove a violation of the ordinance and the dog owner was aware the dog was loose at the time. So it's
Right.
crazy, but we've seen this defense where let's say the dog got out of the backyard, your neighbor,
Mhm.
and you're getting your mail and they have no idea their dog's out. They have
Mhm.
no idea the dog's never gotten out of the backyard before. They have no reason to believe that there's a problem with the defense. They have no reason to believe there's a problem with the fence. That is a valid defense, meaning they didn't know their dog was out at the time, which means you cannot rely on the leash ordinance to prove your case. You'll have to fall back on the dog was vicious and find a prior aggressive act. So your neighbor's dogs that are so sweet and kind,
Mhm.
I would be very worried about your case if you were bit with the dogs off leash. If your neighbors didn't know the dog was out, you might have a problem because like you said, those are really sweet, loving dogs. There probably is no prior aggressive act.
Right. So, right after a dog attack, what evidence is most at risk of disappearing or becoming harder to confirm?
So I would say there's two things that we really want to jump on right out of the gate. The first and most important is probably video evidence. There are all sorts of cameras now that people are using for security reasons to keep an eye on their property. And the number one uh, most popular is the Ring camera. And for example, I have a Ring camera and I only pay for a certain amount of storage. It's 30 days, and after 30 days, it's gone. So it is so, so important that right after an attack to knock on doors, to find neighbors, to walk through the neighborhood because it's easy to see. You can see the front door little
Mhm.
doorbell ringer, and a lot of times over garages, there are cameras. You can see them, and we will try and track down those neighbors, see if they're willing to help, at least preserve the videos. A lot of times, even the dog owner themselves may have video of the dog running out, and we will send what's called a spoliation letter to the dog owner, requiring them to hold on to the video and maintain it. A lot of times, they're nice people and they've just, something bad has happened. And a lot of those folks are really nice and will send us the video
Mhm.
because they feel bad about what's happened. I would say the second biggest piece of evidence that we need to get in a dog bite case right out of the gate are witness statements. Because what happens when it first occurs, people are worried, they want to help, they ask how the client's doing, and they're much more willing to be involved. But as time goes by, 30 days, 60 days, 90 days, they lose interest. So it's really, really important that we get witness statements. If liability could be an issue, we get affidavits, signed affidavits.
Mhm.
That way, if that witness disappears, moves, goes to Europe for their job, whatever, we have an affidavit and we can use that affidavit in court if need be to show one of the things we're going to need to show, which the biggest one is prior aggression. Now, the witnesses can also be helpful because one of the defenses that comes up in a lot of cases is that the dog was provoked or I mean, my client assumed the risk, and that witness can help give us a statement that destroys those defenses that maybe my client did something to provoke the dog.
Okay. Now you mentioned um, videos and photographs can show the injury, but what other details in photos and videos may become important as the case develops?
So in the landlord case, the videos and photos are going to be very important to show the location because we want to be able to prove it's a common area, and it's not always as clear cut as the parking lot. I mean, that's an easy one. We're
Right.
not going to need photos of the parking lot as badly as we might in a mobile home case when there's ramps. We've had cases before where there's really long ramps from the door all the way down, like a 10-20 foot ramp for people to walk up to their mobile home.
Mhm.
And the question is that a common area? If you take the mobile home and leave, do the ramps stay there? And typically the answer is yes. So there's a pretty good argument that that's a common area. So we want to have a photograph of those ramps to show just how long they are and to be able to prove that that area is for the benefit and use of all tenants so they can come and go and visit each other.
Mhm.
I would say another very, very important part of photographs is not just the photographs from the day of the bite that shows the damage the dog has done. It's not just the photos of the healing process, of the bruising, scabbing, if there's plastic surgery. But what's really important is to get photographs of our clients from before this ever happened. I want to see, especially if it's a face bite, if it's a bite to a body part that is not, covered by clothes. We want before photos just as much as we want after photos. So I would say those are really important because a juror can say, "Oh my God, look how cute that child is. Oh my goodness, look at them now. Look how beautiful that woman is. Oh my gosh, look at the scar she has on her face now." Those before photos are almost as valuable and as important as the after photos.
So let's talk about medical records. What do they reveal beyond the diagnosis or the treatment itself?
So the medical records are hugely important. They're going to have several, I would say three things that we want to look at beyond what you've already mentioned.
Mhm.
The first is they're going to have pain scales, which is very important. 0, there's the happy, sad face, and then
Right.
10, there's so sad looking. So there's pain scales to show actual what kind of pain our client was in, which is very helpful.
Mhm.
Next, it's going to have the actual doctors' names. We're going to need these doctors because those doctors are going to have to testify as to what their diagnosis was and what the prognosis, meaning what does the future hold for our client. Because interestingly enough, in Georgia, clients cannot talk about what their diagnosis is. Now, it's not that difficult to say, I was bitten by a dog and, I lost this part of my arm. But if there's more complicated injuries, for example, broken bones, surgical issues, torn tendons, clients can't testify as to the specificity of what those injuries are. The next piece of evidence that is very, very important is called the HPI, or the history of present illness. There are many times that a client won't call animal control and they've called us 6 months or a year later, and they never called animal control because they're afraid that the dog will be put down and they just don't want that on their conscience.
Mhm.
So there's no actual official record of the bite ever even happening. However, what's the first thing that happens when you go to the doctor? What does the doctor say? So, what's the first thing that happens when you go to the doctor? When he walks in the room, he says, "Tell me why you're here. Tell me what happened." That's called a history of present illness. And that's when we tell the doctor what happened. That is an official record and can be used to corroborate what our client is saying happened when they were attacked by a dog. Because who goes to the doctor and
Right.
tells them wrong information, because the doctor needs correct information so that they can actually properly diagnose and treat. So the HPI is very, very important, especially for our clients who call us months after an attack and they've never called animal control because they were afraid animal control might take this person's dog away or worse,
Mhm.
destroy the dog.
Now, we talked a little bit about this earlier, David. So I wanted to circle back to this, talking about prior complaints, leash issues or earlier aggressive behavior, how it can become important in these cases. So, how are the facts investigated?
So that's a great question. So let's say we have a case and it's not a leash law ordinance, and we've got to do a lot of investigation because we got to find that prior aggressive act. So the first thing that we would do that a lot of times works is we just get boots on the ground. We go knock on doors. We ask our clients. One of the great apps out there is Next Door Neighbor app, or sometimes there's neighborhood Facebook groups.
Mhm.
Scour those message boards to see if there's anything about this dog on those message boards. A lot of times there will be gold
Mhm.
in the Next Door Neighbor app or neighborhood Facebook groups. The next thing that we do is I will call the animal control officer. So if animal control is called, I can call them on the phone. Hey, this is David Zagoria. I'm representing John Doe for the dog bite that you investigated. Thank you so much for your work. You know, we're trying to deal with the insurance company. They're making things difficult. Have you ever been called out to that property before? Is anyone in your department, do you know? Can you ask around if they've ever been called out before? And that gets easier when we're in smaller jurisdictions.
Mhm.
When we're in huge metro Atlanta counties, that can be tough, but we do it anyway. But as we get further out, uh, they know these dogs that are problem dogs. Still, a lot of times in the metro area, they'll know. If there's a prior incident that had occurred years prior to our client being injured, we will do open records request to animal control because we can get a history for that property and for that dog owner. So if the actual animal control officer who investigated our client's bite wasn't working when the prior bite occurred, we can try and find records from other animal control officers. And an open records request is a request made to a government office, the police, animal control, where they have to turn over records. And a lot of times we'll find what we need in those records. We can also get evidence from HOAs, homeowners associations. We've had our clients text or email the president, vice
Mhm.
president, secretaries of the HOA. Hey, I got attacked by this dog. I'm sure you heard about it. I'm trying to deal with the court case. Has anything like this ever happened before? And a lot of times we will get information about it happening before. We also get the information from the dog owner. I will call the dog owner and
Mhm.
say, listen, I'm not trying to put your dog down. I don't want anything bad to happen to your dog, which is true. I don't want anything bad to happen to anybody's dog. I will ask them, has anything like this ever happened before? We need your help in dealing with your insurance company. Can you talk to me about your dog and his temperament? And a lot of times, you know, these are people that are not bad people. It's not intentional. They don't want their dogs to have hurt someone. And a lot of times they're great and they're willing to help. If none of that pans out, the best place we ever get this evidence from and where it turns up time and time again is from veterinary records. We get the records. We can't get them before we file suit, but as
Mhm.
soon as we file suit, we can get records from the vet. We can get records from groomers. And a lot of times there's stuff in there. It'll have medication like Prozac for dogs.
Mhm.
That's a sign that there's something wrong with this dog.
Mhm.
I've seen vet records where it says it's got a sticker in there that says caution will bite. And that's it. That's
Wow.
the smoking gun we're looking for.
Yeah.
But that's the Hail Mary. We're willing to do it, certainly when there's a child hurt, when the injuries are bad. If we can't find what we need in the pre-litigation phase from the animal control officer, from the neighbors, from social media, next door neighbor apps,
Mhm.
our Hail Mary is always going to be the vet records. And a lot of times that Hail Mary pass is caught.
That just reminded me about even the Ring app. Like I see all the time where people are posting about, a dog or, if one has been aggressive. So I didn't think about that is an absolute gold mine of a place to find information.
It's terrific, and a lot of times it can be on the dog owner's personal Facebook page
Mhm.
that they may have posted something about it. Oh, Fido nipped somebody. Thank God it wasn't too bad.
Yeah.
That's all I need.
Right.
So social media and people being on social media and talking about their dogs can be very, very helpful. We have a case right now where a dog was out running loose, and my client got on the next door neighbor app, and we found three posts where people were saying, "Hey, this dog's out. Whose dog is this?" And there's
Mhm.
actual pictures of it.
Mhm.
So that's very, very helpful because in that case, they didn't know their dog was out. However, they know their dog has a history of getting out,
Mhm.
yet they're still putting it in the backyard. So
Right.
no surprise that the dog got out again. There's three times before where the dog had gotten out. So the scienter of having to know it's out at the precise moment is not as important because they have scienter that they're putting a dog out in a backyard that won't restrain their dog. And when I say scienter, I mean just
Mhm.
knowledge. They knew.
Right. Well, that brings up another question. I'm just going off my own townhome situation here, where there is no separation of, there's no fence, there's no enclosed backyard. It's just free, wide open grass, right? You just know that this portion here is mine for the where the patio is. So sometimes I've seen dogs the owners let the dog out so they can go use the bathroom, and they just kind of run back and forth until they get tired, I guess, and go back. So in that situation, because would that still be considered a common area?
That is a great question. And so what I think are you saying is if somebody's dog is out
Hmm.
loose, but on their own property, like it's not run off their property, how
Yeah.
does that affect the dog bite case?
Right.
So the rule in Georgia is that if the dog has the ability to leave the property, it's in the front yard. If it wanted to go chase a squirrel, it could go right off the property and get it. That is an unrestrained dog. It's unleashed. It's not restrained.
Okay.
That is a leash law violation. And this is a caveat to that that people typically don't understand. If that dog runs a mile away and bites a child, homeowners insurance still covers it. The bite does not have to happen on the dog owner's property for
Okay.
homeowners insurance to cover it. Homeowners will cover a dog bite wherever it occurs. It is essentially a liability policy for the homeowner. We actually had a case that I took because I enjoy playing golf where two men were at a driving range. There was a driving range bay right here and one right next to it. And our client bent over to put the ball on the tee, and the golfer in front of him reared back to hit the ball that he was hitting and hit our client in the head with a golf club.
Oh my goodness.
His homeowners covered it. Homeowners provides liability coverage for the homeowner, wherever they are, unless they're driving a car, driving a boat, or flying a plane, because you got to have coverages for that.
Hmm.
So a lot of people are confused and they don't think that the homeowners will cover it because the bite didn't occur at the dog owner's house. It does.
Okay. All right. So I think I'm stuck on this common area thing here. so
Sure.
so there is for example, like a greenway area where people are running and jogging and walking their dogs or letting their dogs kind of run behind them when they're on a bike and they're not on a leash. And I've gone for walks and I'm thinking, oh gosh, is the dog coming at me or is the dog going to follow its owner or wherever? So if I were to get bitten or bit by the dog, um, what happens then?
So you would not have a case
Okay.
against the municipality that is in charge of the green space, like the Beltline,
Okay.
right? So the Beltline is a public space. It's the government, the city, the state built it. But the reason they're not liable is everything in a dog bite case is about scienter. So the city doesn't know anything about the dog. So the city's not going to be liable. What you're going to have to do is if that person's dog, it's just some person who's on a bike or rollerblading and their dog bites you,
Mhm.
you're going to have to get their information because if they run away,
Right.
it's like if you get hit by a hit and run driver, there's no, they're gone. There's no one to sue. So you'd have to get their information. Hopefully they're decent enough people who stay, check in with you, give you their contact information. They, oh my God, please, if you're going to go to the emergency room, let me know. I'll take care of it.
Mhm.
That's usually what we see. People are usually really big hearted and feel really bad when their dog bites somebody and they want to help, at least at the beginning. So you'd have to get their contact information. And if the dog was leashed at the time, you'd have to prove a prior aggressive act, right?
Hmm.
Or at least, they've chased or attempted to bite or bitten someone. If
Right.
the dog was unleashed, let's say they're rollerblading and their dog's just running along with them,
Hmm.
you would only have to prove that they were in violation of a leash law.
Okay.
And clearly they would know that the dog was loose at the time because they were with the dog rollerblading and the dog's running along with them.
Right.
But there would be no case against anybody except the dog owner or whoever that person was, because it could be the keeper.
Hmm.
It brings up an interesting point. So if that person, let's say, was a dog walker,
Right.
for example, let's say you were in Europe and you had a house sitter taking care of your dog and they're walking your dog,
Hmm.
and this happens, they're the keeper of the dog. They would be liable at that time, most likely. Now, if your dog had a history of biting and you failed to tell your dog keeper or dog walker, hey, my dog can be aggressive and bite people, I need you to muzzle them, I need you to keep them away from people.
Hmm.
If you didn't give a proper warning to your dog walker, then you could be liable. But if there'd been no aggressive history at all, then the dog walker is going to be liable.
Oh, that's good to know. Well, let's go back
Yeah.
to witnesses. So, what makes witness
Okay.
statements useful in a dog bite case, and what makes them less reliable? I know people's memory can kind of get shaky sometimes. So, but what makes them less reliable?
So witness statements become very important, usually when we have an issue of liability. For example, I represented a little boy who was standing on the edge of a fence and he had his arm on the fence, and the neighbor's dog was a cane corso, very, very powerful, large dog. And he was watching ducks land on a pond in the distance. The neighbor's dog was fenced in,
Mhm.
jumped up and bit his arm and removed a large portion of the
Oh,
muscle.
wow.
So the dog was fenced in. We had to find a prior bite. So we found some records by mailing every single neighbor around them. And we found a witness who then produced an animal control report when the dog chased her. So we had to get an affidavit from her immediately to lock in her testimony in case we lost her.
Wow.
She was lovely. She wanted to cooperate. She was afraid of the dog, and she didn't have an axe to grind.
Mhm.
That's the problem sometime with witnesses. I've had the other scenario happen where the witness wasn't as concerned about the safety of the neighborhood. And their first question to me is, how much are you going to pay me? And obviously, we cannot pay witnesses for their testimony. They get a $30 appearance fee for depositions,
Mhm.
plus they can get their mileage, but we cannot pay someone for their testimony for obvious reasons. Um, People aren't always honest when they're paid to speak. So that would be a big issue, is if somebody is pressuring us
Mhm.
to pay them large amounts of money, hundreds of dollars to come testify. I have to explain to them, we can't do that. It's not legal under the law. And I don't want to have to subpoena you if I don't have to,
Yeah.
because we want a cooperating witness. So that, credibility of witnesses is always a huge issue.
Mhm.
And some of the factors in credibility is if they know this neighbor and they have an axe to grind with the neighbor, anything that might cast doubt on their truthfulness can be an issue. The biggest one I've seen is when they want hundreds and hundreds of dollars to cooperate and give their statement, which of course I just can't do that.
Like we've mentioned before, sometimes ownership or control of the dog is not always clear. Like you said, it could be the dog walker that's, the keeper of the dog. But what facts help establish who may be responsible?
That's a great question. So I'll talk to you about a case I had where there was a defendant who had a friend that was going through some medical difficulties. So she allowed that friend to come move into the house.
Mhm.
And the defense in the case, so the friend had no insurance, no assets. So he wound up suing the homeowner. And the defense in the case was that's not my dog. I'm not responsible. They were just living with me for a short time. But the evidence that we were able to pull from the depositions established that the homeowner was a keeper of the dog. So, what are some of the factors? She fed the dog. She allowed the dog to sleep in the house. The dog had a bed in the house and a crate, and it was in the main part of the house. It was not in the let's call her the tenant. She wasn't paying rent it, but the dog wasn't confined to the tenant's room. The dog was allowed to roam the house. The dog had its bed in the main part of the house. The dog was allowed to roam the house when the homeowner had guests over. The homeowner fed the dog. She played with the dog. On occasions, she got dog food, purchased dog food for it. And she was affectionate and enjoyed having the dog in her home. That one had just about every factor you can have. And it's common sense. It is someone who takes care of the dog, takes responsibility for the dog, enjoys the dog. Because we've had the opposite too. We've had, oh, I had nothing to do with the dog. It stayed in my roommate's room. I didn't like the dog. I didn't pet the dog. And I hardly was ever home at all because I work all the time. Real hard to prove that person's a keeper. But
Right.
the more responsibility that the homeowner takes for the dog, the more affection they give the dog, the more they do for the dog, then we're going to be able to prove keeper. The less they do, it's a lot harder. And we've had the opposite factual situation as well. We've had a roommate who didn't allow the dog to roam around the house. There was no dog bed in the middle of the house. He didn't feed the dog. He didn't give it water. He required the dog to stay in the tenant's room, and it was all the way downstairs. And the homeowner was rarely home. He worked all the time. So that's going to be a tough one to win. And in fact, we couldn't prove keeper. And the more you can prove they took care of the dog, they fed the dog, they gave the dog affection, allowed the dog to roam the house, all those factors add up to keeper. And somewhere in between that first case I mentioned and the second one is a gray area where there is no bright line as to bang, bang, bang. That means you're the keeper. That means you're responsible.
Mm-hmm. So, can you share an example of a dog bite case where one piece of evidence changed how the case was evaluated?
So I can. We were retained on a case where our client tried to resolve the matter herself, which was a big mistake.
Hmm.
She believed the insurance company was going to try and do right by her and help her. She was bit in the face, and it occurred inside her friend's house. They offered her a very low amount of money, and that's when she hired me about a month before the statute of limitations expired, meaning the 2 years that you have was almost up. We filed suit. We got the defendant served. And I thought it was a good case. I knew it was a good case. She was bitten to her face. It became a great case. It turned out that the dog owner, my client's friend, had been bitten by the dog. And in the litigation process, we found that they admitted that it had bit them, but they weren't sure how many times.
Oh, wow.
We found out who the rescue was that they turned it over to. They decided not to keep the dog, but they didn't want to put it down. So they gave the dog to a rehabilitation facility that tries to help dogs to do better, to get over aggression. And in that paperwork, they disclosed that the dog had bitten 6 times.
Wow.
And it was so bad that the dog became aggressive with the rescue personnel. It bit one of them. They became afraid. They determined there was nothing they could do for this dog. And unfortunately, the dog had to be put down. So, and we find that evidence a lot.
Mhm.
The evidence that the dog has bitten numerous times pretty much guarantees what's called punitive damages in Georgia. If the dog's bitten once before, then the jury can decide, do we need to find punitive damages against this dog owner to make sure nobody else gets bitten?
Mhm.
And once you have multiple bites, I can pretty much guarantee you a jury is going to award punitive damages. So then that's a huge piece of evidence because now the case was worth this much for my client being bit in the face, but then it becomes worth so much more because of punitive damages coming into play.
Mhm.
That's very powerful evidence, and it's really very helpful when we find it.
Wow. I wonder, are they still friends? That's-
They are not, and
yeah.
I'll tell you why they're not friends. they're not friends because it was an unbelievable betrayal.
Mhm.
They never told my client that their dog had bitten before, ever. So the choice
Mhm.
that she should have been able to make for herself over whether she felt safe around this dog was taken away from her,
Yeah.
and it destroyed the friendship when she found out 6 prior bites.
Mhm.
Now, before that, they were still friends. The friend said, "Hey, I understand my insurance company's not doing right by you. They've given you a lowball offer. I know you have to sue. I know I don't want things to be weird. Go ahead and sue. You need to do what you need to do to protect you. I'm sorry it's gotten this far." And the friendship was strained, but they still remain friends. But once this information about 6 prior bites came out, that was it. Friendship
Yeah.
was over.
I don't blame her. Don't blame her at all.
Yeah, if I had a friend that invited me over to their house and they didn't tell me their dog could be a problem and they took the choice away from me about whether I want to be exposed to a problem dog or not, I might have a real hard time being their friend. And if their dog bit my kid,
Mhm.
there's no way.
Right.
Friendship's over.
Yeah, absolutely. Once a dog bite case moves toward litigation, what separates strong evidence from evidence that may not hold up under scrutiny?
So once we get a case that becomes obvious, this is going to need to go into litigation, which, to be honest with you, is probably 60 to 70% of our cases.
Mhm.
We've got all our evidence pretty much locked down at that point. We've got the animal control reports, we've spoken to animal control officers, we've gotten video, we've found neighbors, or we've at least attempted to do all that, and we've got everything locked in. The evidence that then becomes really key is our client. Is is our client ready to be open and vulnerable?
Mhm.
And most of them aren't. And so we have to work with our client on being open and vulnerable about how this incident has affected their life. And I'll give you an example. It can be very difficult. And a lot of times our clients will talk about things that nobody cares about.
Mhm.
The classic example is they always ask, "What could you do before this dog bite that you could no longer do?" And I had a client, I've had clients say, "I can't walk stairs." Well, nobody likes to walk stairs. That's not compelling.
Mhm.
So we have to get our clients in the frame of mind is what is important to you? What do you value in your life that's been taken from you?
Mhm.
And once we can start getting into that conversation about how it's changed their life. For example, I've had a client who was a runner and he was knocked down, broken hip. He can't run anymore. That's huge because jurors understand what they love, what they're passionate about, and if that was taken from them, how much money they would want to make that right.
Mhm.
There's a saying among trial lawyers, and that is jurors do not give money to people they don't know. And how do they get to know you? You've got to be open and vulnerable about the emotions around your injury
Mhm.
and what your life is going to be like because of this injury. So that is the real work that we start doing once we go into litigation
Mhm.
is working with our client on what's been taken from them that's meaningful.
Wow, that's powerful the way that you just described that. If I were a juror, I would think I would pay attention to, oh wow, this person can't run anymore because of this.
Yeah.
Yeah.
When I was a young lawyer, it was, people it didn't click for me as a young lawyer.
Mhm.
People would talk about our clients would testify, "Oh, I can't do my laundry. I can't do my household chores." Nobody wants to do that.
Right.
No one's going to give you money for doing that kind of stuff. They want to know what you love.
Mhm.
Golf, fishing, gardening, cooking. These are things that make life worth living. And when that's taken from you or made more difficult to enjoy, it brings real power and connection
Mhm.
with jurors. And even if the case doesn't make it to jury, it creates a connection with the attorney that's defending this case and the adjuster who's looking at the case to say, "Oh my God, this person can no longer garden." When they cook, they have a hard time. I have a client with a hand bite, and when she tries to do jars, she can lose her grip because she's lost her grip strength and she keeps dropping jars.
Yeah.
That's a powerful narrative that, frankly, anyone who has a heart is moved by.
Mhm. Thank you so much, David, for breaking this down today. Evidence after a dog This has been super informative.
Well, it's been a pleasure. It's been great to work with you again. I look forward to our next episode.
Well, that is it for today's episode of the Trial Lawyers Injury Podcast with David Zagoria. If you'd like to learn more about David Zagoria and Zagoria Neely Injury Attorneys, visit lawzagoria.com. Thanks for listening, and don't forget to subscribe, leave a review, and share the show with someone who may need trusted guidance after a serious injury.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.